All right, hello everyone, and welcome to today's lecture where we will be going over intersectionality and intervention. So, to place this lecture within its proper context, make sure that you watch the lecture before this one or that you have done the reading so that way you understand exactly where Kimberlé Crenshaw is going with her argument and what she's doing within law. So with that stated, let's go ahead and get started with our roadmap. Where are we going today? First of all, we're going to begin with a flashback like we always do. Then we're going to move over to key terms. Then we're going to take a look at why Kimberlé Crenshaw is writing this piece. And we're also going to look at the three cases that are undergirding Kimberlé Crenshaw's argument. That is the Catherine Reed versus General Motors, Moore versus Hugh Helicopter Incorporated, and Payne versus Travenol. And then we're going to end with intersectionality and intervention. So by way of review, let's go ahead and get started with our flashback. So the last lecture that we had looked at the origins of contemporary black feminism and philosophy. And the key thing to remember from that is that black women are writing about their lived experiences. And those lived experiences both inform black feminism as well as the philosophy of black feminism. And which tradition is this in? Who might this connect with? It connects with Charles Mills. It connects with Cheryl Harris. It connects with Derek Bell. Why? Because all three of them are writing about a lived experience and theorizing from that space. So in this instance, we see that the Combahee River Collective is very much in the tradition of critical race theory and making clear what their experiences are when they are talking about social movement spaces in terms of working within the civil rights movement, black power movement, etc., with black men, but also in the feminist movement with white women, and how these things are coming to impact their experience in society as well as individuals. And along those lines, what is also important for us to remember is de jure versus de facto. De jure, law as it is written; de facto, law as it is experienced or as it is lived or by custom. And that critical race theory as well as critical race feminism looks at the chasm between the two. It really studies it. So that way we have a clearer understanding of society and how law impacts society as it's acting on and structuring society at the same time. Now, a key thing to remember here is that we are now in this turn of critical race feminism. So make sure you go back and watch the previous lecture so that you understand exactly where the arc of the class is at this particular point in time. What is also important that we remember, pardon me, is stand your ground laws. And we looked at how stand your ground laws wasn't just necessarily about, keeping one from being criminally convicted, but it was primarily about two main things: protecting an individual's assets and keeping costs down for the nation state. Right? And that these rights, these benefits, these entitlements were guaranteed by way of what? Whiteness as property, right? But the key thing here was that cost was kept down for the nation state and that an individual's assets were protected. What does this lead us into? Neoliberalism, right? This is week 3, lecture 1, where we learned that neoliberalism, is about this philosophy that says, hey, we're taking public resources and public goods and we're privatizing them. That this is also about the government minimizing its costs as well as minimizing government interference. In other words, doing away with regulations so that capitalism can have what? Free reign, free market capitalism, right? That is what neoliberalism is all about. For more on that, make sure you check out week 3, lecture 1. Then what is also important to recall as we move into today's lecture is strict scrutiny, because we covered that in week 2 when we looked at whiteness as property. And we remember that strict scrutiny is a legal standard that is used by courts whenever the government wants to enact something that may infringe upon the rights of a protected class of people. That would be race, gender, religion, national origin, etc., right? That whenever the government wants to do something that may significantly impact those groups, They've got to narrowly tailor the law in such a way to where only the thing that the government is trying to achieve will be accomplished. Now, why is remembering that important? Because what we understand is that as strict scrutiny is laid out, as it helps to protect something while bringing something into being, it also allows for injury to take place among, or within, I should say, those protected classes in many instances. From there, what is also important that we also remember, and I know I'm going through these relatively quickly, right? But you can also go back and watch previous lectures where this is expanded upon further. We're just doing a flashback to help get that foundation set up for today as we transition over into key terms. But what is also important to remember is the purpose of critiquing critical race theory as a field of study is about deepening and expanding the bounds of CRT so that we have a more complete understanding of society, that our analysis is incisive, that it's clear, that it is accurate, that it is right on. And accordingly, right, not only are those people like who study capitalism important to critical race theory in presenting their critiques, but also this is where critical race feminism comes in, because what are they saying? They're saying, hey, we see you, we hear you, but you need a gendered analysis in there, okay? So, by way of that, let's move over into our key terms. And there are 8 of them. And the reason why laying down these key terms are important is because, again, critical race theory, critical race feminism centers what? Law, right? And so there are some understandings that we have to have before we can lean over into what Kimberlé Crenshaw is writing and why she's writing it. So let's begin by understanding exactly what Title VII is. Title VII is simply prohibitions against employers that discriminate on the basis of race, color, religion, gender, national origin, etc. In other words, discrimination is outlawed by way of Title VII. But Kimberlé Crenshaw's work is going to come to question that, by the way, right? But so just stick that feather in your cap, stay there, but at least you know what Title VII is. That it prohibits employment discrimination based on race, color, religion, gender, national origin, etc. What is also important to know for today's lecture is what are protected classes? What are these classes that are protected in constitutional law that have been historically relegated to the margins of society and harmed by way of public policy and different laws and statutes that have been passed? Those groups are race, color, sex, pregnancy, sexual orientation, gender identity, national origin, age, and age defined as 40 or older. Now we can place a critique here about what happens to 39 and younger, but that is not this particular law class, right? We're just introduction to critical race theory, and we're just going over what the protected classes are. Other protected classes are disability as well as genetic information, i.e. your family medical history. Obviously, this has implications, right, for insurance companies. But all of these particular groups are protected classes within federal law. Another thing that you will need to know as Kimberlé Crenshaw is laying out her argument is the but-for legal standard. So just like there is a strict scrutiny legal standard, there is a but-for legal standard. And what is that? That is a legal standard that is used to determine whether a defendant's actions was the cause of injury, harm, or a discriminative action. In other words, but for them doing this, then this would be in place. That's going to be really, really important in looking at these 3 cases that Kimberlé Crenshaw is laying out. Next up, what you saw in the reading a lot was this term single axis. And what is it that Kimberlé Crenshaw is referring to when she's talking about a single axis? She's talking about an analysis, in this instance, a judicial analysis, which centers and prioritizes a singular subject position in framing and or understanding public policies, laws, statutes, etc. So in other words, that a judge will only consider race. A judge will only consider gender, right? In their lens and their analysis of law. That is what she means by a single axis framework, that only one thing is considered. And some bells should be like setting off here in terms of like, oh, I get it, right? In terms of that's exactly what she's getting at in the reading, right? Some things should be setting off. So what else is important to understand? What discrimination is. And when we refer to discrimination, what we are referring to is a process that is adopted typically by institutions or workplaces, right? Which advantages and or disadvantages those of protected classes, right? So one can be a member of a protected class in advantage, i.e. white women, and one can be a part of a protected class in disadvantage, i.e. black men, as is what takes place in our reading that Kimberlé Crenshaw is critiquing, right? So make sure you keep these things in mind. Also important to understand is what law means by disparate impact. What is disparate impact? Because that undergirds really what Kimberlé Crenshaw is doing in the text that we read. So disparate impact is when a practice is neutral in its wording, but when it is employed, it actually harms a group of people, typically those that are of what? A protected class. What are examples of this? College admissions or hiring practices that are done by companies. What is an example within college admissions? The SAT, the ACT. What we are very clear about as sociologists is that depending on which side of town you are on, it depends on what type of resources that you get. And typically the more funded sides of towns, right, that receive more of those tax dollars by way of real estate values, right? That's another class, right? That's Sociology 101. But nonetheless, those particular sides of town tend to be more prepared for the SAT, ACT, within their classroom settings, as well as with private tutors that parents and or family members are able to afford, versus what is happening in the black and brown communities, right, that are on the other side of town, is that they are not able to be prepared for the SAT, ACT in the ways in which the more wealthier sides of town are. What does this result in? That means that when a given university says part of the admissions process is your SAT, ACT scores, that means that disparate impact is about to take place. Because you have a pool of students, right, who are all applying to the same university that has seemingly neutral admissions requirements, but that when the research is done, we know that one group is more advantaged than the others, and therefore disparate impact takes place. That is what disparate impact is. That is also why, this is a side note, that you need more than test scores to be admitted to the university. Because what test scores just say is that you had access to preparation, whereas we may have another candidate over here who's very well-rounded, very balanced, amazing grades, but does not test that well because they did not have access to preparation, much in the way that maybe another candidate did, who may have somewhat okay grades, but are privileged by way of an economic advantage background. You see what's happening there? That's that. I'm not going to get too far into that. That's another course. Someone that's in education, right, can teach you that, the politics of education. So in rounding out our key terms, what is also important to know as well is that a plaintiff is a person that is someone that is bringing the case, right? Most of us know this. The plaintiff is the person that is bringing the case, whereas the defendant is the person who is defending themselves against the claims of the plaintiff that is defending the case. Okay? So, with all of this in mind, and with all of this in place, with the flashback and the key terms, let's go ahead and move forward. And let's talk about why Kimberlé Crenshaw is writing this particular piece and why it is important. And what we have to remember is that Kimberlé Crenshaw is at Harvard University with Derek Bell as critical race theory is being developed and theorized. And they're theorizing out of what? Lived experience. So Kimberlé Crenshaw is aware of what has taken place within the legal landscape of the United States, as well as its what? Its social impact. What are we getting at here? De jure versus what? De facto. Law as it is written, law as it is lived. There it is, right? She is also aware, like the women of the Combahee River Collective that we read for the previous lecture, of the lived experience of black women, particularly because Kimberlé Crenshaw is in fact a black woman, okay? So why then is it that she begins to etch out intersectionality in the late 1980s and the early 1990s? Being legally trained, she is acutely aware, here it is, of the single axis framework. We just defined that out. She's acutely aware of the single axis framework, which law often employs to both qualify and decide cases. Zeroing in on judges' propensity to use single axis frameworks in their decision making is important for Kimberlé Crenshaw because as judges utilize law to protect groups by using a single axis framework in the process of that protection, it permits other marginalized groups to be further injured than they already are. You all see what's taking place here? That as one group is being protected, another group is being exposed to a type of harm. This is what Kimberlé Crenshaw is getting at in her piece, right? What is also important as this is taking place with those particular groups is that it further reinforces social misrecognition and marginality, while at the same time rendering those same protected classes as non-cognizable within law. Do you all see the move that is happening here? That's important. So if you read Kimberlé Crenshaw's piece, this ought to be setting off some bells, right? So now important to Kimberlé Crenshaw is the fact that this judicial processes, right, this single axis framework negatively impacts black women more often than not. In other words, as decisions are made in courtrooms concerning civil rights law and key constitutional protections, those persons whose lives are often positioned as collateral so that other marginalized groups can have access to rights as well as favorable legal decisions are black women, right? So accordingly, courtrooms and legal decisions are not only arbiters of black women's experiences in larger society, the courts become part of the experience of black women, even as the court superimposes further injury in their lives. This is going to be really important to remember when we start rolling through these cases, okay? So, as a result, oftentimes, civil rights cases, cases of discrimination and or constitutional protections are heard. As these cases are heard, the rights, the protections, and the access of black women to the benefits of a particular rendered decision in court is often predicated upon the extent to which black women's lived experiences map onto both black men and white women. Who does this sound like? It sounds like the Combahee River Collective, right? When they were talking about black women's liberation in the reading that we did for the previous lecture. So we're seeing some connections being made here, right? So accordingly, to make her point, Kimberlé Crenshaw looks at three cases. She looks at the Catherine Reed versus General Motors. She looks at Moore versus Hughes Helicopter Incorporated, and she looks at Payne versus Travenol. And she's looking at these cases not in terms of like cherry picking them, but she's looking at these cases as a type of symptom or a type of example of a larger pattern in practice that is happening in law. Now, notice how just like critical race theory, critical race feminism is grounded in and centered in law. If it is critical race theory, there must be some type of study or consideration of law involved. This has implications for the fact that this is, again, not taught on a K through 12 level, because you need to know legal theory. You need to know juridical standards, right? You need to know all of these things, torts, constitutional law, all of that good stuff. That law is required, right? So unless they start opening up, law schools on the K through 12 level, right? They bring in someone to teach it, then this is not existing on the K through 12 level. And I'll say more on this right here, right before we move on. That critical race theory is not just history. It's not just political science. It's not just sociology. It is about how law maps onto these areas, as we discussed in the first lecture. That critical race theory is interdisciplinary, transdisciplinary, multidisciplinary, but its center, its nucleus is law and a very clear understanding of it, right? And why is this important? It is important because law is the primary mechanism that shapes, guides, and informs society. Law determines what is and is not permissible, while at the same time determining what is and is not socially normative. With that being stated, let's take a look at each one of the cases that Kimberlé Crenshaw is looking at to marshal her argument and what is happening with them. So let's begin with the Catherine Reed versus General Motors and what is taking place with this very well-known American company, right? So what is being brought in this particular case, if you did the reading, is a lawsuit against General Motors because black women are saying, hey, we're not being hired in the process here. That civil rights legislation has passed and that we are still not being represented within the workforce of General Motors. Now, important to note here is that General Motors did not hire black women prior to 1964. However, those hired after enduring the 1970s lost their jobs by way of layoffs that were structured around a seniority type basis, right? So why is this, why are these two things particularly important? Because prior to, General Motors was hiring black men. They were also hiring what? White women. You start to see where some issues are coming in here. And black women are saying, hey, we are not being hired. And by the time we get to the 1970s, right, here we go back to the flashback, what is emerging onto the scene? Neoliberalism. That is deregulation, right? It is all about capital. And the nation is hitting a recession at the same time, right? So we begin to see the emergence of neoliberalism. And as all of this is taking place, GM decides to do layoffs. And as they are doing those layoffs, here comes the disparate impact. This is why we went over the key terms, right? They're saying our rule is seniority. So if you were the last in, you are the first out. Seemingly neutral on its surface, but its disparate impact was that black women were ultimately let go at General Motors because they were the last folks through the door. Do you see how that is happening there, right? And what happens in this case is that the judge issues a summary judgment for General Motors. The judge says, hey, they didn't do anything wrong. There's no discrimination that is taking place here. And you as black women do not get a particular protection that is afforded to you by law because you are not what? A protected class. Watch the moves here. This is law. This is not something that's theoretical, right? This is not something that's just out there. This is what actually happens in law. Now let's look at page 141 to get more into the judge's argument. This is what the judge said, right? Here we go. Quote, plaintiffs, who are the plaintiffs? Black women who are bringing the case. Judge says this: plaintiffs have failed to cite any decisions, in other words, legal precedent, right, which have stated that black women are a special class to be protected from what? Discrimination. Remember our key terms? Here we go. The court's own research, so he says, listen, I sent out my paralegals and we did our thing. And the judge says what? Quote, the court's own research has failed to disclose such a decision. We can't find this anywhere in law that black women constitute a special class. He goes on to say, the plaintiffs are clearly entitled to a remedy if they have been discriminated against. If they have been discriminated against. This is the actual transcript from the case. The judge goes on to say, quote, however, they should not be allowed, they, black women, should not be allowed to combine statutory remedies, race, gender, peep game. Because what was happening with GM? They were already hiring black men. They were already hiring white women. Do you all see what's happening here? Right? De jure, de facto, somebody's getting it. I'm super excited about this. I know somebody's getting it, right? So the judge says again, however, they, black women, should not be allowed to combine statutory remedies to create a what? A new super remedy, which would give them relief beyond what the drafters of the relevant statutes intended. Thus, this lawsuit must be examined to see if it states a cause of action for race discrimination, sex discrimination, or alternatively either, but not a combination of both. In other words, what the judge did in this moment was he rendered black women as a non-protected class, that they were then non-cognizable before law. And by doing that, he acknowledged the rights of black men as well as the rights of white women, but who became the collateral in order for those rights to be recognized before law was who? Black women. This actually happened. The Catherine Reed versus General Motors. This actually took place. And by way of making this decision, what else did the judge do? The judge implicitly stated that black women are not guaranteed access to 14th Amendment rights. What is that? That's the Equal Protection Clause. Do you all see what is happening here? This is important. So then Title VII, which was about employers not being able to discriminate, etc., was then leveraged to preclude black women, to exclude them out. And therefore, the refusal of 14th Amendment protections. In other words, black women did not get access to civil rights protections as black men and white women got access to them at General Motors. This actually happened. This is on the books. So we're not talking about, how one feels or how one perceives reality. This is what happened. This is what is shaping black women's experience in corporate America, and why Kimberlé Crenshaw is writing what she is writing. So that's one case, right? Now let's move forward to Moore versus Hughes Helicopter. Now what's going on in this case? In this particular case, black women are in the workforce. They are there. And what they are saying is, hey, they're bringing this claim that alleges that Hughes Helicopter is practicing both race and gender discrimination in promotions. Here we go again. Because what did the judge say in the previous case? That black women are not entitled to, quote, a super remedy. That it has to be one or the other. And here we have another case with Moore versus Hughes Helicopter, and black women are bringing the case alleging that the company is practicing both race and gender discrimination in promotions. And what are they going to utilize? They're going to utilize a disparate impact claim. That's why we went over the key terms. And what black women are saying in this case is that, hey, that Hughes Helicopter Incorporated, they have some policies on books as it relates to promotions that it looks neutral. But the outcome is that, hey, we're excluded from these promotions. And what they do to marshal their evidence in this particular case is that they collect the data so that it just isn't about feelings. Because, people always say, oh, well, they're always in their feelings. And black women said, nope, here's the statistical data. Here is the evidence, right? Because they are the plaintiffs. So they are responsible for bringing the evidence to stand behind their claim. And that particular data that they brought to the court, it demonstrated a disparity between men and women. Peep game. In that, excuse me, pardon me, in that disparity was more prevalent between men and women, more so than black and white men. In other words, what black women were saying was that, listen, there is a gendered issue here. And that gendered issue comes to impact black women in a specific and particular way. But what does the court do in this particular instance? The court rules that Moore, representing black women, is not the proper representative for women as a protected class group. In other words, that a black woman cannot stand in for the protected class of women because she lacks the necessary attributes to do so. There are two things that are happening in this instance. That black women in this particular case, again, become legally non-cognizable, and that womanhood becomes refused and qualified in the same instance. Let's look at page 144 so we can get a more clear understanding of what it is the court is saying here. What does the court say? The court says they're going to go back to the EEOC, right, claim that Moore submitted in order to get to this case. And the judge says this, quote, Moore had never claimed before the EEOC that she was discriminated against as a female, but only as a black female. This raised serious doubts as to Moore's ability to adequately represent white female employees. In other words, that the rights, what's the critique here? That, and this is critical race feminism, by the way, that the rights, the privileges, the benefits, the whiteness as property rights, hear it, of those who were white women at Hughes Helicopter was protected because the judge interpreted the EEOC complaint that was filed by Moore to only be representing black women. And in this instance, he said that you cannot represent white women because of the fact that you are a black woman. Do you all see the moves that are happening here? That is important to understand and underscore. One more time. That the property interest in whiteness is protected by way of negating the disparate claims, because the disparate impact claims of black women, which renders them legally what? Non-cognizable, and therefore refuses their what? Their 14th Amendment Equal Protection Clause rights in service of white womanhood. Do you all see what's happening here? And the judge from the bench says, oh no, you can't represent all women. You can't do that. And what does the judge do in this particular instance? He does what? He narrowly tailors. What does this sound like? Strict scrutiny for a protected class. Y'all see what's going on here? So that as strict scrutiny is laid out in defense of white womanhood, black womanhood is refused. So one group is afforded the protections of strict scrutiny. Another group is not. That's what's happening here. So the judge narrowly tailors who could be a class representative by employing race, whiteness as property, right? And thereby allowed for the discrimination in Hughes Helicopter to be perpetuated, right? And discrimination against black women, right, becomes permitted And he also negates their access to, again, what? 14th Amendment protections. So this means that even in this instance, black women are not covered by Title VII. This is why Kimberlé Crenshaw is writing this piece. That it's not just theoretical. That black women are incurring a type of injury by way of law, because as law protects one group, it exposes another to injury. So when one reads law, you have to read it really in an inverted way to get the analysis. You have to invert it to understand what law is really saying. So in this particular instance, as white women are protected, black women become exposed to what? Perpetuated discrimination in the workplace that is supposed to be protected against by way of Title VII, and then they don't get access to their 14th Amendment protections, right? Now, what happens further in this case? In Moore versus Hughes Helicopter Incorporated, the court also limits the admissible statistical evidence for Moore, who's bringing the case. The judge looks at the statistical evidence and says, all right, let's comb through this really quickly. And he slims that evidence down to black women only. Do you see what's happening here? Here goes the injury, because he's saying you can't represent women, all women, so let's take that data out. You can't represent all black men, so let's take that data out. We're going to talk about black women only. And it was determined that, wait a minute, Hughes Helicopter, they're actually not being discriminatory. By way of the judge adjusting the goalposts, by way of the judge saying, okay, women over here, black over here. There goes that single axis framework. And he used that to determine who was qualified for higher positions. And by the time he got through doing that, he said, okay, cool. That means that there should only be 2 black women in management. And accordingly, he said, Hughes Helicopter, you're innocent. You're good. You can go. You got 2 people there. That means you're not being discriminative in the workplace. All because the judge used a single axis framework to control for gender, to control for race, and thereby expose black women to continued discrimination in the workplace at Hughes Helicopter Incorporated, and also refusing black women access to their 14th Amendment right protections. Do you all see what's happening here? And this happens every day in law, by the way, right? Because we can also talk about, and this is a side note, we can also talk about the particular ways in which black children are unalived, and the people who actually commit that unaliving being found not guilty is a further injury to black women. That is an interruption in an unacknowledgement of their reproductive rights. Because if the whole point of reproductive rights is that one should be able to have full control over their body, which we agree with, then that also says that what that also implies is that one should be able to see the full arc of that which they choose to do or produce with their bodies. And that to the extent that one's children are unalived and that unaliving is protected by the state, then one does not have access to equal protection rights of the 14th Amendment, and their reproduction rights are not acknowledged by law. What am I saying? That reproduction law and the battle over it began long before the Trump administration stepped into office and started doing stuff in the Supreme Court. That what is being experienced on the national level within the United States has always been the experience of black women, down to sterilizations, right? Which was so common that it was called the Mississippi appendectomy for those that were in the South during the 1960s. Right? So we're talking about things that are historical here, is my point. that it's not just what's happening in these three cases. That law has always acted in the United States to place women, black women, as a type of vestibular, as a vestibular subject, whereby which the rights of others are made possible and rendered onto the nation state. Right? Let's look at Payne versus Travenol. And this is the last case that we will look at. Now, what's taking place here? Because what's different about Payne versus Travenol is that black women are actually awarded something. But I want you to watch how this plays out, right? So the action that's alleged here, what takes place is that there is discrimination that is happening at Travenol, which is a pharmaceutical drug company, right? And that the plaintiffs, who are black women, they bring their case, which is a class action lawsuit, on behalf of all of the employees at Travenol, all of the black employees at Travenol. They bring a class action lawsuit. However, the court says what? The court says, black women, you cannot represent all black people. Literally, this is the case, right? Get into the reading. That you cannot represent all black women. All black folks. You can only represent black women. And accordingly, the court did find discrimination at Travenol, but they granted Travenol's request to narrow the class that would be awarded to only black women. In other words, black men were not included in this by way of the property rights and whiteness that Travenol utilized. And I'm going to break that down in just a bit, right? But it is the request of Travenol that says that, nope, we're not giving this to all black people, that takes center here. That what Travenol wants done is privileged and centered. That's the critique. That's the analysis. Not necessarily, well, black women got something that black men did not. That's not the critique here, right? The critique is that black women were not allowed to advocate for blackness as a group, for black individuals as a group at Travenol, but that the rights, the privileges, and the protections of Travenol as a company were protected, and that their bottom line, neoliberalism, that their bottom line was preserved as much as possible. Now, how do we get to this Travenol as a corporate entity accessing whiteness as property? Let's look at it. So Travenol as a corporate entity, again, laid claim to the rights and protections of whiteness as property. How? Because corporations, via Northwestern Life Insurance Company versus Riggs, that was a 1906 ruling from the Supreme Court, found that what? That corporations are people and have a right to 14th Amendment protections. Therefore, the 14th Amendment rights superseded. There it is. Remember when we talked about whiteness as property and stand your ground laws as an example that allows those that retains whiteness as property the ability to exceed the bounds of law. And here is, we are doing the same thing where Travenol is allowed to take advantage of 14th Amendment protections as a corporation that is seen as a person. That's the law. 1906, again, Northwestern Life Insurance Company versus Riggs. That they are accessing those 14th Amendment rights that are guaranteed via whiteness as property, right? And we also talked about the inversion of 14th Amendment rights in week 2, but nonetheless, they're accessing those rights, those benefits, those protections, those entitlements that are entitled to them via whiteness as property that allows them to exceed the bounds of law, that allows them to determine how protected classes will and will not be awarded. Therefore, the rights of Travenol in this instance, even as black women are being awarded, the rights of Travenol exceed the rights and protections of black people as a group, and Travenol is permitted to split up the group according to their benefits. Do y'all see what's happening there? And the injury that takes place here is that law, even as it awards black women in this particular instance, is saying, black women, you cannot speak for black people as a group, right? With that being stated, what does that lead us into? that leads us into understanding intersectionality as an intervention or as a contribution. We discussed that in the previous lecture at the beginning. So what is intersectionality? What is it, so that we are clear? Because it's more than just like multiple identities, right? But intersectionality references the critical insight that race, class, gender, sexuality, ethnicity, national origin, ability, age, etc., that all of these things, that they don't operate as a unitary, mutually exclusive entity or type of social identifier, but rather as reciprocally constructing phenomena which interact with and are reinforced by social structures and institutions that causes identity to matter. In other words, intersectionality is not just, okay, I'm black and woman, or I'm white and man, or I'm white and woman, or I have this ability, or I don't have that ability. That's part A of intersectionality. Part B of intersectionality is that social structures and institutions causes those identities to matter, right? When we go back to Hugh's helicopter, we see how black women as a class and how the court caused that identity to matter. That black women could not be representative of the gendered group. Right? And the court caused that identity to matter. So when we talk about intersectional identities, and everyone has an intersectional identity, by the way. When we talk about intersectional identities, again, it's not just about, okay, well, this intersects with this. It's not, this intersects with that. It is also about how institutions causes those identity to matter, whether for one's advantage via whiteness as property or one's disadvantage being non-cognizable by law. That intersectionality works on both sides of the fence. And within this capacity, critical race feminism, here we go, going back to the previous lecture before this one, has the capacity to liberate everyone, because intersectionality is not, yes, it is born out of black women's experiences, but it helps us to understand an analysis of law that impacts everyone, because no one lives, what did Audre Lorde say? No one lives a single issue life. We all live intersectional lives. And so we must understand that when all of these things come together, race, class, gender, sexuality, orientation, national origin, ability, age, whatever have you, that when these things are mapped onto social institutions, such as courtrooms, such as hospitals, right? Such as educational institutions, then one can be in the hospital. And what did Serena say? That she was not believed when she was in pain. There's a reason why black women are the #1 demographic impacted by maternal mortality. Intersectionality, that these institutions causes their identity to matter. By way of the work of J. Marion Sims, who developed the OBGYN field, who developed that field off of the bodies of enslaved black women who were not given anesthesia as he did his practices. Look it up, Dr. J. Marion Sims, right? And this is how the pain that black women say they are in comes not to be believed by the medical field, right? Or this idea that those who are black can withstand more pain. That's where all of that comes from. There is a reason for all of this, right? Or the way in which colleges do admissions. Again, going back to the SAT, ACT, and black and brown students that are located in one community as compared to those who are white and elite in another community, and the way in which they shape admissions causes the identity to matter in those instances. And this is how this not only what intersectionality is, but this is why it is important. Because it points us back to institutions, institutional processes, as well as structural processes. And this is why Kimberlé Crenshaw is writing. And in turn, this is why critical race feminism is so important as a contribution to critical race theory. Because again, it allows us to have a more incisive, accurate, clear, and detailed analysis of law in society and how law both acts on society, as it impacts society, and as it constitutes society at the same time. All right, that is today's lecture. I will see you in the next one. Have a good one. Peace.